Hey, folks. Hey, surprised to find you all here. Welcome to the Law of Self-Defense show for, what's today? Thursday, September 22nd, 2022. For those who may not know, I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you so much. That is greatly appreciated. Welcome, everybody. Probably be a bit of a shorter than usual show today. A couple things to go through. One is some video we have of some rapper or rapper associated people having a shootout in a parking lot. Shootout's probably the wrong word. Only one guy brought a gun and fired it. He's been charged with murder now. Fortunately, we have high quality surveillance footage of the event, so there's stuff for us to talk about. Does this look like a lawful shooting or not? So I'm going to talk about the relevant legal issues here on the multi-stream. The multi-stream is what everyone's watching at the moment. It's streaming on YouTube, on Rumble, and for our Law of Self-Defense members on the member dashboard, I think. Yes, indeed, there it is. So welcome, Law of Self-Defense members on your dashboard. I'll be talking about the legal issues that would control the analysis in the case of this rapper shooter. The shooter apparently is a gentleman called Chaka Zulu. He's the manager for a rapper called Ludacris. I don't know who any of these people are. I guess I'm old, but that's the story. There was a confrontation in a parking lot. Chaka Zulu shot and killed a dude. And now has been charged with murder. We'll talk about the videotape. So we'll talk about the relevant law. I'll describe the videotape here on the multi-stream. When it comes time to play the actual video, I will play the video on today's show, but only on the Law of Self-Defense members stream. So we'll get to a point in today's show where I'll cut off Rumble, cut off YouTube, and we'll actually review the video only for our members because YouTube just demonetizes everything I put a video on. So that's just the way it is. Sorry, folks. On the other hand, being a Law of Self-Defense member only costs about $0.25 a day. So if a month's worth of legal analysis of use of force defense from the nation's leading expert in self-defense law is worth $9.95 a month to you, you can join at lawofselfdefense.com/join right there on the screen. And if you're going to do that, I suggest you do it sooner in today's show than later. It does take a few minutes for you to be emailed your username and password and stuff like that. Less than $0.25 a day, folks. I mean, frankly, if this content's not worth your time, I'm not sure why you're here at all. If it's not worth less than $10 a month, but that's your call to make. And I'll also do some Q&A, meaning we have a bunch of questions that were sent into my desk from various Law of Self-Defense Platinum Protection members. Our Platinum Protection Program is the only way to have me consult on your legal case if you're involved in a use of force event. If you want the nation's leading expert on self-defense law to consult on your case, the only way to have that done, we don't take outside retainers anymore. We only do legal consults for our Platinum members, and for them, we do it for free. No $10,000 retainer minimum for our Platinum members. They're covered simply for being Platinum members, and we don't take retainers from outside, from non-members at any cost. I'm not available for your case unless you're a Platinum Protection member. You can learn more about that at lawofselfdefense.com/platinum. But one of the benefits of being a Platinum Protection member is you get to send your legal questions directly to me. They come to my desk and I answer them personally. If a Platinum member has asked for the question to remain private, then we certainly keep it that way. But generally speaking, we'll just anonymize the question and answer it in forums like this. So if you're a Platinum member and sent in a question recently, today is probably the day we're going to answer it in one of our shows. Okay, so let me turn. Oh, one last thing. I almost forgot. Can't believe I forgot. Once or twice a year, we do a Law of Self-Defense advanced course. This is our full day Law of Self-Defense course on, as you might expect, defense of self, defense of others, defense of property, interacting with the police, consciousness of guilt evidence, how the legal system actually works, how prosecutors decide what kind of cases to bring to trial and not, what kind of how to make yourself hard to convict if you're ever compelled to use force in defense of your family. It's a live class. We stream it over Zoom. There's plenty of opportunity for Q&A. You're with me all day. We do maybe two of these a year. The second one and the last one for 2022 is coming up now in less than a week and a half. We have our last Law of Self-Defense Advanced course for 2022 occurring a week from this Saturday. So it's on Saturday, October 1st, 2022. We still have a few, I think 5 or 6 seats available for this, and we just want to fill them up and get this over with. So we're offering those last 5 or 6 seats at 50% off. So if you'd like a day's worth, and I know a bunch of you in the comments have taken this course, so feel free to leave your honest reviews of what this Law of Self-Defense class is like and if it's worth attending. I know the responses will be positive. They always are. But if you'd like to take advantage of this last opportunity for 2022 to take our Law of Self-Defense Advanced class, now would be the time. Save 50%. Otherwise, you have to wait till usually late spring next year before we do this course again. You can learn more about this and take advantage of that 50% off option at lawofselfdefense.com/advanced, lawofselfdefense.com/advanced. Okay, so let's talk about this Chaka Zulu shooting. Yeah, I don't think that's a real name either, but whatever. People are free to call themselves whatever they like. Chaka Zulu is reportedly the manager for a rapper named Ludacris. I don't think Ludacris has any participation in these events per se, so he's just bad luck for his name to get dragged into this, I guess. But of course, I don't really know the relationships between any of these people. In any case, Chaka Zulu got into a confrontation with one and then several people outside what looks to me like a nightclub. There's lots of people standing around. Lots of rapper type people, lots of Becky's hanging around, lots of bystanders hanging around, pretty crowded parking lot. Chaka Zulu and another gentleman whose name doesn't really matter for our purposes, they seem to be having a verbal tiff. There's a little bit of chest bumping. The other gentleman appears to turn away, and Chaka Zulu goes on the offense, starts punching him, gets his back. Basically, the victim of the punches here gets turned against a car. Chaka Zulu throws a punch or two. Doesn't get much done because the rest of the crowd pretty much turns on Chaka Zulu. He takes a punch to the head. A couple of other people join in. It begins to look like a pretty good beatdown. Chaka Zulu goes down in the parking lot. There's some stomping going on. 2 or 3 people at least. I would certainly characterize that as a deadly force attack. Force likely to inflict death or serious bodily injury. Even if Chaka Zulu were in the wrong, even if you believe he initiated the first punching of the victim here, which probably I think is a pretty realistic perception of events, that would have been a non-deadly force attack against which a deadly force response is unreasonable. And had Chaka Zulu pulled out a gun while he was getting stomped in the parking lot and shot to defend himself, he'd probably be legally justified. But of course, it doesn't happen that way. What happens is the stomping stops, the attack stops. Chaka Zulu gets up. He kind of walks a few steps towards the back of another vehicle, reaches to his waistband, retrieves the gun, and then starts shooting at one of the gentlemen who was beating him. Fires a second shot at a second gentleman who he misses the second time. The first shot, unfortunately, he strikes the victim. Unfortunately for the victim, he strikes the victim. The victim's mortally wounded, dies, and that's why Chaka Zulu is now charged with murder. And then there's some other incidental action that is not important, but I'll cover it when we play the video for our Law of Self-Defense members. Yeah, the Beckys take off pretty quick once the fight starts. Not quick enough, frankly. They're still in the vicinity when the shots start being fired. Not a good place to be, but there you go. So the question is, at the moment, Chaka Zulu fires the first shot and then the second shot. For each of those, they're each distinct events. They're different firing pictures, sight pictures, for example. They're clearly distinct events in short proximity to each other. So within a second or so of each other, but really different shots, different intended victims being fired. So when he fires each of those shots in that moment, is he facing an unlawful, imminent, deadly force threat from the people he's shooting, or frankly from anybody else. And the answer, I think, with respect to the first shot he fires is maybe. The first guy he shoots is standing upright, not obviously retreating. It's a little hard to tell because the video gets a little pixelated at that point, deliberately edited by whoever put the video on the internet. But it's not obvious that the victim, the first shot victim, is actively trying to retreat from the fight. Maybe, but it's ambiguous. The second shot, that guy is running full speed away. No weapons and evidence. Was he presenting as an imminent deadly force threat at that moment, or was he just being shot at because Chaka Zulu was pissed because of the beatdown? Probably that. But that guy wasn't hit. So what would the criminal charge be? Aggravated assault, no battery because he didn't actually hit him. Aggravated assault's a serious charge, but it's not a killing charge, and he's been charged with murder. It's the killing charge you'd want to worry about in this context if you were Chaka Zulu. So the real question is the first shot, the killing shot, the fatal shot. Could that one have been legally justified? Was in that moment Chaka Zulu facing an apparent, a reasonably perceived, even if mistaken, reasonably perceived imminent deadly force threat? Well, even the first victim is not displaying a weapon. So he is not by himself a deadly force threat. He's not advancing. He's not retreating, but he is standing there, could be ready to fight. We don't know what's being verbalized, by the way. There's no audio on this tape. And, but could Chaka Zulu have perceived him as wanting to continue the attack? Maybe. It's ambiguous, but the argument is there to be made, and the state would have to disprove it beyond a reasonable doubt, right? So it's not a matter if the jurors properly instructed. It's not a matter of whether or not you think it's more likely than not that he reasonably perceived a deadly force threat from the first victim, but whether the state can disprove that perception of a reasonable threat beyond a reasonable doubt. And particularly in the context of the fact that Chaka Zulu was not, moments ago, he was facing attack not merely by that one person, but by a whole group of people. So could he have believed that the group beatdown was going to start again? Perhaps. And I believe this took place in California, by the way. California is, if you don't know, a stand your ground state, a very robust stand your ground state. So Chaka Zulu would not have had a legal duty to retreat per se. Although it looks like at the time he fires a shot, he really is getting back into the fight. It looks like the fight's over to me, which of course then would raise the question of, well, if he was still reasonably perceiving an imminent deadly force threat at the moment he fired the first shot, was the fight actually over? Was the beatdown actually over? The stomping attack over? And when he pulled the gun out of his waistband and came back into the fight, was the first fight sufficiently obviously over that what Chaka Zulu did was, in effect, initiate a second fight, a deadly force fight himself, that he was the unlawful deadly force aggressor in the second fight? In that case, he would lose the element of innocence in that fight. Remember, folks, there's 5 elements that generally must be present, up to 5 elements for a lawful claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. In this case, in California, avoidance, probably not a problem. Let's, for our purposes, assume it's not. But innocence could be lost here by Chaka Zulu if the jury's convinced beyond a reasonable doubt that although he was let's pretend he was the victim in the first stomping attack, even that's uncertain, but let's pretend he was the victim in the first stomping attack, could he nevertheless still be the unlawful deadly force aggressor in the second fight, the fight that he would have initiated? I think the answer there is probably yes, in which case he's lost self-defense on the basis of losing the element of innocence. At the moment he fires the shot, was he facing any imminent threat from the person he shot? It's ambiguous. They don't appear to be clearly retreating. Could they have shifting their weight forward? Maybe they were just locked in place. That's going to be a fact question for the jury. It's not obvious to me either way. But even if he was facing an imminent threat, could it have been reasonably perceived as a deadly force threat? Because that's what he would need to see for his shooting to be lawful self-defense. Before you can use deadly force in self-defense, you need to be facing a deadly force threat, a threat likely to cause death or serious bodily injury. again, I think there's an argument to be made there because just moments before, he was, Chaka Zulu, the shooter, the victim of a group attack, a group stomping attack. Could he have believed, based on what he was seeing or what was being verbalized to him, that that was about to begin again? If so, and that perception is reasonable, well, then he would be defending himself against a deadly force attack. So I see, of course, commentary on this on Twitter and so forth, and people seem to be jumping to conclusions that this was clearly self-defense or clearly not. Frankly, I think the situation is a lot more ambiguous than that. And it's robust ground for robust arguments to be made to a finder of fact. I'm not surprised that the prosecutor is taking this one to trial. I mean, he does, of course, have to disprove self-defense beyond a reasonable doubt, but only one of those required elements: innocence, imminence, proportionality, avoidance, or reasonableness. And by the way, although California, where I believe this occurred, is a stand your ground state, so avoidance would not normally apply. If Chaka Zulu can be characterized as the initial aggressor in a second fight, the second fight being after the stomping was over, after when he goes to the gun, he's initiating arguably a deadly force second fight. If Chaka Zulu can be credibly presented to the jury, proven beyond a reasonable doubt to be the initial aggressor in that second fight, well, then he's lost self-defense anyway, regardless of the issue of avoidance, because he's lost the element of innocence, unless he can regain innocence. And how do you regain innocence here? Well, you would regain it by withdrawal and communication, withdrawing from the fight and communicating your desire not to fight anymore to the other party. And if you believe he lost innocence, he certainly did not regain it by withdrawal and communication. He goes right to the gun and starts firing shots. So that's the nature of the video. That are the legal issues that would be key to an analysis. Again, there's no absolute answer here, folks. The criminal justice system is not a magic box where you feed law and evidence into one side, crank the handle, and get perfect justice with a capital J out the other side. There are ambiguous facts here, even with the video. And of course, we don't know, for example, if Chaka Zulu made statements that would go to his subjective state of mind, if words were said to him that might guide his reasonable perceptions of the degree of threat he was facing, all that would come out in a jury. So there's a certain degree of ambiguity here. I could easily see it going either way in front of a jury, and that's why I'm not surprised the prosecutor is taking this to trial. The prosecutor here figures he has a shot at convincing a jury that this was not self-defense. But it's not a black and white, cold-blooded shooting. By the way, he's charged with murder. One possible argument here is one of imperfect self-defense, or a killing under what's called sufficient adequate provocation. The first is where you have you don't have perfect self-defense. You don't have all the elements required for perfect self-defense. If you qualify for perfect self-defense, you're acquitted. You have zero criminal liability. What you did was simply not a crime. Imperfect self-defense is where you almost have self-defense. So you don't have perfect self-defense because you are missing an element. So you can't get an acquittal based on self-defense because you fail the legal defense of self-defense. But you might qualify for imperfect self-defense, and it's imperfect because it cannot get you to an acquittal. And the argument there basically is that you have an almost perfect claim of self-defense, but your perception of the threat was unreasonable, was not objectively reasonable. You may have genuinely believed you needed to use deadly force in self-defense, but a hypothetical, reasonable, and prudent person in the same circumstances would not have shared that belief. So you had an irrational belief in the need to use deadly force in self-defense. Well, an irrational belief in the need to shoot someone in self-defense is not lawful self-defense. You're to be lawful, your act of self-defense has to be reasonable, including objectively reasonable. So if your belief in the need to act in self-defense was irrational, can't qualify for self-defense. But it might qualify for imperfect self-defense. If that's the only defect in your claim of self-defense, it could qualify for imperfect self-defense. And imperfect self-defense is a defense that's available in most states. It is very aggressively applied in California, in particular by criminal defense attorneys. You see it all the time in the appellate court record. What happens with imperfect self-defense is you're charged with murder. It only applies in the context of being charged with murder. You're charged with an intentional killing. You can't get acquitted on the grounds of self-defense for the reasons we just described, but you convinced the jury of imperfect self-defense. You had a genuine belief in the need to act in self-defense, but it was irrational. It was not objectively reasonable. What happens then is that what would have been a murder conviction becomes a manslaughter conviction. So 10 to 20 years in prison instead of life in prison without possibility of early release. So manslaughter sucks. Unless the alternative is murder. That's what imperfect self-defense does for you. The other thing that could happen here, given that he's charged with murder, is he could end up with a voluntary manslaughter conviction on the basis of adequate provocation. So what voluntary manslaughter means, in effect, is that you intended to cause the harm. You intended to harm someone. But because you were provoked to a very substantial degree, the law refers to it as adequate provocation. The law distinguishes a cold-blooded killing between an adequately provoked killing. Cold-blooded killing, just murder. Under adequate provocation, there's a heightened emotional state, and the law says, well, under that heightened emotional state, you could not have formed the specific intent to kill required for a murder conviction. And the classic example here is like when a spouse comes home and finds their spouse in bed with a lover and whips out a gun and shoots them both. That's not a lawful shooting, not lawful killings. You can't just let that person go free. But the argument is, well, it wasn't just done in cold blood. It was done in hot blood. It was done under adequate provocation, and that would also mitigate murder down to manslaughter. So either of these I could see applying here. Either Chaka Zulu's perception of the need to use deadly defensive force was irrational, can't be lawful self-defense, but could mitigate murder to manslaughter on the grounds of imperfect self-defense, or the stomping beating he had just suffered moments before constitutes adequate provocation, that in the heat of the moment he shot in hot blood, that he was not, given the adequate provocation, was not able to form the intent required for murder. Therefore, at worst, this is manslaughter. I would expect his defense counsel to make both those arguments at court. Can't imagine why they wouldn't. So that's how things are going to work for Chaka Zulu. So I do have the video for Chaka Zulu, and we are going to go over that video. But I'm going to wait on that until, let's see, until a bit later in the show. We're going to cut off the YouTube, cut off the Rumble, and just play that video for our Law Self-Defense members, both because those members are awesome, and second, because YouTube just demonetizes me and stops promoting my videos every time I put one of these surveillance camera clips on. So I'm just not doing it anymore on YouTube. That's just the way that is. Before we get to that video, though, I'd like to dig through some of the recent questions that have come to my desk from our Platinum Protection, from our Law Self-Defense Platinum Protection members. So let me take a look at these, and we'll answer a few of them, and then we'll wrap up YouTube and switch over just to the Law Self-Defense member show. By the way, if you are a Law Self-Defense member watching this, I would you don't have to do anything. Just open up the live show on your member dashboard, and there's no switch. It'll just be completely transparent for you. If you're not a Law Self-Defense member, well, you might consider becoming one at lawselfdefense.com/join, and now would be the time to do that. So you're all set. You'll have gotten the email with your username and password in time for the switch. It's only about $0.25 a day, folks, to be a Law Self-Defense member, so it's not a ton of money. At lawofselfdefense.com/join. All right, so we have a question here from one of our Platinum members, from Larry. So Larry asks, question on the element of reasonableness. And by the way, folks, I have not reviewed these questions, so they're brand new to me too. Question on the element of reasonableness. And to the extent that my knowledge and understanding matters versus what a jury would find reasonable. So it's important to keep in mind, folks, that what controls your legal fate is not what you think is reasonable. What controls your legal fate is what other people think was reasonable. It's what the police, what the prosecutor, what the judge, and most important, what the jury believes was reasonable. You can believe something was reasonable all you want, and that's important in decision making in the heat of the moment when you're actually defending yourself. But your legal outcome is not controlled by that. Your legal outcome is controlled by what the jury in particular thinks was reasonable. So continuing with Larry, in Mas Ayub's Mag 40 class, so Mas Ayub, if you don't know Mas Ayub Group, you can just Google that. He's a famous self-defense instructor, quite a bit of expertise in the law. He was actually kind enough to write the foreword to my book, as you see right there. By the way, you can get this book for free, real physical book, at lawofselfdefense.com/free book. You can buy it on Amazon for $25 and shipping and handling. We'll give you the book, just cover the cost of the shipping and handling. We'll eat the $25 cost of the book. You can get this at lawofselfdefense.com/free book. It's a good read, folks. Look at the reviews on Amazon. Over 1,000 reviews, 5-star rated book. But don't buy it there. Buy it. Get it for free from us at lawofselfdefense.com/free book. So Larry writes, in Mas Ayub's Mag 40 class, I took notes and mailed them to myself, and from your class in Utah supplement. So folks, we have state-specific law supplements, courses for every state. Larry's in Utah. He says he took the quizzes from our course and passed, but I've heard you say sometimes we must document training, and other times I misunderstand and get the feeling it's all reliant on what the jury finds reasonable. Isn't the key about what a theoretical, reasonable, and prudent person would have done, knowing what I know, and thus left not entirely to the jury? So I sense some confusion there. So the jury is supposed to look at you, look at your conduct, and decide whether or not you were both subjectively reasonable and objectively reasonable. That's what reasonable, here at the bottom, that's what the element of reasonableness means. And for good guy cases of self-defense, we basically always have subjective reasonableness. That just means you had a genuine good faith belief in the need to act in self-defense. People like us are not shooting other people if we don't think it's a necessary self-defense, but that subjective belief by itself is not enough. It also has to be objectively reasonable. Would a theoretical, reasonable, and prudent person, a third party, have shared your subjective belief, or was it irrational? If it's irrational, that's not enough. You fail objective reasonableness, you fail self-defense. If it was rational, if it was reasonable, well, then you've locked in the element of reasonableness. But the jury decides what was reasonable and what was not, right? They're making the call on whether or not you, in fact, qualify for the elements of self-defense, whether, therefore, your use of force was self-defense and not a criminal act at all. But the jury is also instructed that in evaluating whether your perceptions, decisions, conduct in self-defense were objectively reasonable, they're supposed to take into account, they're supposed to customize that hypothetical, reasonable, and prudent person for you, which gives it kind of a subjective tint, right? But it really is part of objective reasonableness. So the way that works is, would a hypothetical, reasonable, and prudent person in the same circumstances have had the same perception of the need to use deadly force in self-defense? So surrounded by a hostile crowd, just having suffered a beating, those kinds of factors. It's not a reasonable and prudent person in a vacuum. It's a reasonable and prudent person in the same or similar circumstances. This also applies to any specialized knowledge you have, specialized training you have. Did you get law enforcement training? Have you taken a course like Mag 40? Have you taken, by the way, the Law of Self-Defense Advanced course? In fact, let me change the little URL here to that. Our advanced course is, of course, taking place, the last one of this year, Saturday, October 1st, 2022, our full day live streamed course on self-defense, 50% off for the last 5 or 6 seats that are available. You can learn more about that at lawofselfdefense.com/advanced. But any kind of training you've taken, self-defense training, Masa's course, my course, any reputable course, you learn things in that course. You develop, you gain specialized knowledge. That's knowledge that a lay person, a normal, typical person, would not be expected to know. The jury will not know. But it's knowledge that you acquire through specialized training, experience, that kind of expertise. If you can demonstrate that you possessed that specialized knowledge at the time you acted in self-defense, well, then the jury is allowed to be instructed on that knowledge So they become better informed because that specialized knowledge could well have played a role in whether or not your decision-making was reasonable. Because again, we're customizing that hypothetical, reasonable, and prudent person. Now it's, was your conduct that of your conduct, your perceptions, everything, that of a reasonable and prudent person, a hypothetical, reasonable, and prudent person in the same circumstances, same or similar circumstances, with the same or similar specialized knowledge, training, education. So they're customizing that reasonableness standard. And to the extent, sometimes, folks, your decisions in self-defense are based entirely on your specialized knowledge. In other words, if you lacked that training, you would have acted differently in self-defense. And in fact, anybody who lacked that training would have acted differently. The risk there is that, of course, the jury does not have that training themselves. So they may be perceiving your decisions as unreasonable because they lack that context of that specialized training. You very much want to make sure that they are informed about that specialized training, taught the way you were taught. So when they're evaluating reasonableness, it's from your perspective as someone with that specialized training. The trick there is you have to be able to demonstrate to the court that you, in fact, possessed that specialized knowledge at the time you acted in self-defense. You only learned that knowledge after the fact. It could not have informed your decision-making in the moment. And therefore, it's irrelevant to your decision-making, your reasonableness in the moment. You're probably all familiar with the Tueller drill, for example. Sometimes called the 21-foot rule, the 7-yard rule, has to do with defending yourself against an aggressor with an impact weapon who's some distance away but can close rapidly and strike you with that weapon. You may have made a decision to use deadly force in self-defense based on the Tueller drill. And that decision could look unreasonable to someone who doesn't know the Tueller drill. Well, if you can show that you'd been trained on the Tueller drill prior to the time you acted in self-defense, you can get the Tueller drill presented to the jury as evidence. So they're aware of it. So they're evaluating the reasonableness of your self-defense in the context of someone who knows the Tueller drill. If they can't do that, if they remain ignorant to the Tueller drill, that may lead them to conclude that your conduct was unreasonable, therefore not self-defense, and off to prison you go. So it really, really matters. But in order to get that evidence in the Tueller drill, for example, evidence in front of the jury, you need to be able to demonstrate, well, you were trained on the Tueller drill prior to your act of self-defense. And this applies to any other kind of specialized knowledge. So how do you do that? Well, you need to document your training. You need to be able to bring into court some evidence, not a lot of evidence, but more than zero evidence that you possess this knowledge. And if you can't document it, if there's no evidence, it doesn't exist as a thing in the legal environment. Now, you don't need a lot of documentation. You're a syllabus from a course that you can prove you attended, your own notes from the course. If you get my book, folks, lawselfdefense.com/free book, read it, make notes in the margins. All of that is evidence. And I talk about the Tueller drill, of course, in the book. I talk about it in the advanced class taking place Saturday, October 1st, last one of the year, lawselfdefense.com/advanced. So be sure you document your training so that, heaven forbid, you're involved in a use of force event and you'd like to get that training introduced to the jury so they can make an informed decision about the reasonableness of your use of force. You'll be able to get that evidence in. I've seen plenty of cases, folks, where people claim specialized knowledge but can't document it. And it's not admitted into evidence, and the jury never sees it. And in most of those cases, those defendants get convicted. Don't let that be you. So yeah, you want this stuff documented. What Larry's mentioning here with Moss's Mag 40 class is, and I took Mag 40. It was called Lethal Force Institute 1. We had a different label then, but it's essentially the same 40-hour class. I took it back in 1995 or 1996. And at the end of the class, and in those days, there were no laptops. We had spiral notebooks. So we just took tons and tons of notes. I filled up several spiral notebooks with notes. Moss recommended at the end of the class that we make a photocopy of our notes, keep the photocopy handy for reference, but put the originals in an envelope, mail it to ourselves, return receipt, so you have to sign for it when it comes back to your house, and leave it sealed in your gun safe with that postage stamp with the date on it. So if you ever have to document any of the specialized knowledge you learned in that 40-hour class, which includes the tool or drill and a lot of other specialized knowledge. You can have your lawyer just unseal the envelope in court in front of the judge. It's got the U.S. Postal Service date stamp on it. That's documentation that you had all that specialized knowledge before then. You don't have to do all that. I mean, you don't have to. There's other ways to document your specialized knowledge. But having said that, you don't have to. I can tell you, it's now 2020. I took this class in 1996. I still have my sealed envelope in my safe with all my original notes from that Mag 40 class. So let's see. I think I answered Larry's question. Let me take a look at the next one. All right. Let's see. All right. Eric from Oregon asks, on the professional interrogator video with Dr. T.C. Fuller, this is a YouTube video and member video we did last week. I think a week prior to today, last Thursday. Dr. T.C. Fuller, a good friend of mine, retired FBI special agent, combat veteran, professionally trained interrogator. He shared with us some of his insights on interrogation. And Eric asks, he covered assert your right to silence and an attorney. How does this apply to the spouse who was involved indirectly as a witness in the self-defense, who also called 911 and will be questioned? Should she also assert her right to silence and an attorney? So in theory, you're only asserting your rights if you're facing criminal jeopardy. In fact, if you're not actually facing criminal jeopardy, and say you're in court and the judge is, you're being called as a witness to testify in court, and you don't want to testify because you're afraid your testimony could criminally incriminate you, you can assert your Fifth Amendment right to silence right there on the witness stand. But the right only really applies in the context of being in legal jeopardy. So the prosecutor could, for example, you could assert your Fifth Amendment right, and the prosecutor could say, you know what? I grant you immunity from prosecution for anything you're going to testify about here today. So there is no legal jeopardy because you've been granted immunity from prosecution for anything you say. Well, if there's no legal jeopardy, you can be compelled by the court to testify. If you still refuse to testify, you can be held in contempt by the court, put in a jail, frankly, for pretty much however long the judge wants. I mean, there's reasonable constraints, but they can apply that kind of pressure to compel you to testify. So you don't have a right to silence no matter what. You have a right to silence so you cannot be compelled to incriminate yourself. If you are involved in a self-defense shooting and your wife just happens to observe it from a distance and she's not an active participant in any way, she's really just a witness, like any other witness, she wouldn't really be expected to be facing any legal jeopardy for that event. So in that sense, in a technical sense, it doesn't really make sense for her to assert her right to silence. And if she were in a courtroom and refusing to testify, we might have the same scenario I just described. The judge could potentially order her to testify if the judge decides she's not facing any legal jeopardy. I mean, there is a spousal immunity argument that comes in here too, but I don't want to get sidetracked. Spousal immunity being the principle that your spouse can't be compelled to testify against you. Let's pretend it's an adult child who is with you, okay? So then we wouldn't have the spousal immunity issue. But that's what would happen in court as a technical legal matter. What about on the scene? So you've shot someone in self-defense. Your wife is standing 20 feet away. She saw the whole thing. The cops show up because you called 911 or she called 911. It doesn't really matter. And now they want to question your wife as a witness. Can she escape questioning by simply asserting her right to silence and asserting her right to counsel? Well, yeah, I mean, she can escape questioning by just not answering the questions. I mean, she doesn't really need to assert her rights. Might it be more palatable to the officers on the scene, detectives who arrive on the scene, if she kind of formally asserts her rights? I assert my right to silence. I assert my right to counsel. Yeah, that would make me hesitate for sure, because it's a formal assertion of rights. And what if it turns out she was somehow involved? I mean, the cops don't know for sure. They weren't there when the shooting happened. What if she, the gun you used, she tossed it to you so you could defend yourself? Who knows, right? But there's some argument to be made that she would have some criminal liability. Well, then once she asserts her rights, they don't really want to be questioning her anymore, because anything they get out of her would not be admissible anyway if they're improperly questioning her after her assertion of her rights. So yeah, I don't think it's crazy for your spouse to assert their rights. Now, when you get to court, might that spouse or that adult child, might they nevertheless be compelled to testify by the trial court? Sure, that could happen. But in the moment, if you what you're worried about is in the stress of the moment, your spouse might start blathering, and you'd like to be able to advise them before any such event occurs that, hey, honey, if something terrible ever happens and I have to use this gun, the smartest move for you, just assert your rights, even if it doesn't make technical legal sense to do that. Just assert your rights so they'll stop questioning you and you don't end up by accident saying something that could be incriminating. Yeah, that's not a bad plan. That's not a bad way to go. All right, so let's go on to the next question. Let's see. Gary from North Carolina asks, if you are arrested, why should you even meet with law enforcement? Can you refuse to meet with them until trial? What legal obligation do I have not to help the police prosecute me? Well, you don't have any obligation to help them prosecute you. Can you meet? Do you have to meet with them? I mean, if you're arrested, they've got you. So you don't, they can apply pressure, right? The prosecutor can apply pressure. They have a certain degree of power and authority to constrain your liberty. You're under arrest in the moment. They can argue for higher bail. We saw in the Rittenhouse case, $2 million bail, or you stay locked up in the county jail or whatever they do in that particular jurisdiction. You're not going to your work. You're not going to, supporting your family. And some of those county jails are pretty tough places, folks. I mean, with tough people in them. You might think that the super tough people are only in prisons where you're where you go after you're sentenced. Jail is often where you're held for, when you're not making bail. It's local. It's a local cage, or for some misdemeanor kind of offenses, misdemeanor criminal offenses that involve jail time. You'd be held in jail. You probably wouldn't be sent to prison for a misdemeanor offense. But jail, local jail can still be a pretty tough place. There can be some bad dudes in there. So you don't want to be in there if you don't have to. Well, that doesn't mean you talk, but it means pleasure. They can make your life unpleasant. You yourself, of course, should never be talking to law enforcement. There's an argument to be made that in the moment at the crime scene, you might want to make sure that exculpatory evidence, the bad guy's weapon, exculpatory witnesses, don't get lost, because generally for good guy cases of self-defense, that evidence is good for you, sometimes vital for you. So I wouldn't want that evidence to go away. But other than that, maybe not even that, but other than that, you don't want to be talking to the police without your lawyer present. And when I say without your lawyer present, I really mean even with your lawyer present. I mean, I don't want my client talking to the police even if I'm there. I may want to communicate to the police, to the prosecutor, why my client's going to be hard to convict. Some representation of what our narrative of self-defense looks like. So if they're reasonable, hopefully we'll have reasonable bail, reasonable arrest conditions, and all that kind of stuff. But I would be telling that narrative to the police on behalf of my client. My client would have explained it to me, and I would then be saying, well, my client is, we're prepared to represent that this happened and that happened and the other thing happened, because I know what words are dangerous to say and I wouldn't say them. You never know what a client's mouth is going to project out onto the table. Could be something bad. Could be something that turns what looks like self-defense into something that looks like manslaughter or murder. So I really don't want my client talking under any circumstances. So, should you meet with law enforcement? Well, it may be advantageous to meet with your lawyer there and your lawyer's doing the talking. If you decide you don't want to meet, it's not entirely up to you, right? They may come get you. And then they got you. That's not a reason to talk. It's just a recognition that they can make things unpleasant for you. Okay, let's see. Next question. Well, I'm afraid I can't answer this one. So this is from Ken, and he lives in a state. I guess he spends time in Nevada. He says Nevada's concealed carry permit is not honored by Georgia. Georgia is a constitutional carry state based on what I've read in your book. May I carry concealed in Georgia? So the reason I can't answer this question, Ken, is I don't do gun law, and there's nothing in my book about gun law. So if you read something in a book about Georgia being a constitutional carry state, that's not my book. That's someone else's book. I know as much gun law as I need to know as a gun owner myself to remain within the legal boundaries, but I claim no particular expertise in gun law, and certainly not in a bunch of different states. Self-defense law, use of force law, yes, that's my area of expertise. But use of force law and gun law are two different things. Use of force law involves, well, the use of force. It doesn't really care about the means of the use of force. It cares a lot whether you're using non-deadly force or deadly force. That's the element of proportionality. By the way, folks, you can get this 5 elements of self-defense cheat sheet for free. We don't charge a penny for this. It's just a PDF download at lawselfdefense.com/elements. But the element of proportionality holds that you can't use deadly force in self-defense unless you're facing a deadly force threat. Otherwise, if you're only facing a non-deadly force threat, you use only non-deadly force in self-defense. And that distinction between non-deadly force and deadly force is very important to self-defense law. But the precise mechanism of the deadly force, for example, doesn't really matter. Whether it's a baseball bat to the head, or a shotgun, or a pistol, or a knife, or an anvil dropped from a great height, the use of force law doesn't really care. It cares a lot about whether or not you were privileged to use deadly force, but if you are privileged to use deadly force, the precise manner of deadly force doesn't really matter. Gun law or weapons law cares a lot about the specific manner of the force. There's licensing requirements. There may be blade length restrictions for knives. There can be all kinds of stuff. I don't claim any particular expertise there or on permitting, right? Some stuff requires permits. Carrying a gun may require a permit. It shouldn't, by the way. I'm a Second Amendment absolutist as far as I'm concerned. Every gun law preemptively applied to law-abiding, mentally sound American citizens is facially unconstitutional. That includes the Gun Control Act. That includes the NFA. All of them. Every single gun law, facially unconstitutional when preemptively applied to law-abiding, mentally sound American citizens. But I'm not in charge, folks, and the states that have gun control laws will be more than happy to put you in prison if you violate their gun control laws. So that's where we're at. I think every state should be constitutional carry. But there's at least one state, again, no expertise on gun law here, but I'm aware of at least one state. It might be North Dakota, it might be Montana. I think it's one of those where they're constitutional carry, but for their residents only. So if you're coming from out of state, if you're a non-resident, you may not qualify for constitutional carry in that state. So those nuances are things you'd have to check up with on a different resource. I will say there's a company I partner with quite a bit, concealedcarry.com. They have a book on the gun laws of the 50 states. I flipped through it. It looks quite good to me. So I would encourage you to consider that as a resource. I don't think it's very expensive, and it would probably answer all these questions. All right, the next. Before we sign off, by the way, I'll also look through the live online questions that have come through in real time from Law Self-Defense members on that dashboard. Not the YouTube questions, folks. Sorry, just the Law Self-Defense member questions. All right, let's see. Okay, this is one I don't know about. Please follow up on this shooting. Not enough facts yet to determine if it was justified. Body found outside apartment. Did resident open door and shoot? Did mistaken visitor force his way in and then fall back after being shot? Did the resident shoot through a closed door? Well, those are a lot of pretty relevant questions. I'll take a look at it. Let me see. The headline here, it's a New York Post, is the link to the news story. Cheer star Cassidy Dunlap's dad shot in critical condition. And here's well, it looks like a dad and a pretty young girl. I don't know who any of these people are. I've never heard of Cheer or Cassidy Dunlap, but then I'm old. But it looks like he was accidentally shot or intentionally shot when he accidentally walked into the wrong apartment in Arkansas. All right, well, I'll take a look at that case. Maybe we'll talk about that in tomorrow's show. So thanks for bringing that to my attention, and the sender, the member, the platinum member, asked to be identified as FB. Fair enough. So thank you very much. I will take a closer look at that case. All right. Next question. Let's see. Video was recently released of a Portland, Oregon security guard in a Lowe's parking lot shooting and killing a man. If this is the wheelchair shooting, oh no, it's a different shooting. All right. So I'm just going to take this one under advisement too. This looks like a new case. Let's see. The video here is, it's not new. Oh no, I covered this case. This is the couple suspected of shoplifting. They're in their vehicle. The security guard, they try to hit the security guard with their car, and he ends up shooting the male in the driver's seat. I did a show on this already. So if you're a law self-defense member, you'll have seen that show. I'm not going to cover it all again here. Let's see. Next question. From Joseph in Arizona. What, if any, cost is associated with a grand jury inquiry? Is there money that the defender would need to put out for defense at the grand jury level? That's a great question. The answer is yes. So the moment you're facing legal jeopardy, you're going to want to retain legal counsel, the most competent legal counsel you can get, because even if you're not yet charged, I mean, especially in a deadly force case, so you're potentially, theoretically facing a felony level charge. You definitely want to lawyer up as quickly as possible. One of the reasons for that is you want your defense lawyer to try to influence the decision making early on. It's almost like a small rock rolling down a snow-covered mountain. At the beginning, it's just a little rock. It's not that hard to stop. At the end, it's an avalanche, and it's going downhill no matter what. Nobody is stopping that. Well, once you're indicted by a grand jury, frankly, once a prosecutor has decided you're going to the grand jury, they're pretty committed at that point to bringing you to trial. So it's much easier to stop that process earlier than it is to stop it later. Very, very difficult to stop the process. I mean, I did consult on one case where we got the murder charges dismissed 2 weeks before trial, but that's because I'm awesome, folks. Normally 2 weeks before trial, especially a murder case, that prosecution office is completely committed to that case. It's not going anywhere. Early on the process, the greatest value I bring to our platinum members when I consult on a use of force case for them is the ability to influence the decision-making early on. So the sooner I'm on board, the better. And of course, with our platinum members, I'm on board since the first moment. We're one of the first people they call, naturally. And that's when we can have the most influence. So you want the lawyer on board early. You don't want to wait till after you're indicted. Now, there's a wrinkle here, and that is, at the grand jury proceeding, the grand jury normally hears only from the prosecution. They don't hear both sides of the story. So the defense is not given the opportunity to present their side of the story to the grand jury. That's not how a grand jury works. The purpose of a grand jury is not to hear both sides. That's what the trial jury is for. The purpose of the grand jury is effectively to say, if we believe everything the prosecution is saying, could this result in a guilty verdict? Is there probable cause to believe that this defendant is guilty if we believe everything the prosecution is saying uncontested? That's the standard for a grand jury. Now, how do you get a no true bill? How do you get a no indictment? Well, imagine you're charged with a crime, and there's 5 elements to that crime. 5 legal elements that would have to be proven beyond a reasonable doubt. Forget the legal defense, just the criminal offense itself. There's discrete legal elements, and the prosecution has 0 evidence on one of those elements. Well, if it's a required element, you can't be guilty of the crime if one of the elements is missing. So you go to the grand jury. The grand jury sees elements 1, 2, 3, 4, 5, and there's no evidence on one of them. Well, just as a technical legal matter, you can't be guilty of that crime. So they would return a non-indictment, a no true bill. But of course, prosecutors are normally smart enough not to do that. They make sure there's at least some evidence. And there only needs to be 1% evidence, folks. Once there's some evidence, there's something for a trial jury to consider. It's up to them to decide what weight to give that evidence. So normally the prosecutor who wants to get an indictment makes sure there's at least something on each of the required elements. Sometimes, though, the prosecutor doesn't really want an indictment. I mean, sometimes what they'll do is they will present both sides. They can present both sides if they want to, but generally both the narrative of guilt and the narrative of innocence, the defense side. Normally, they only do that if they don't really want an indictment. Because if they really want an indictment, they don't tell the defense side of the story. And if the grand jury only hears the guilt side of the story, they invariably return an indictment. I mean, that's why we have the expression that you can indict a ham sandwich, because generally the grand jury only hears one side. There is a little room for the defense here, and that is whatever evidence the prosecution presents in support of the criminal charge. The defense is often given the opportunity to impeach that evidence, not present their own evidence, but to impeach the prosecution's evidence. And that's possible. That can happen. And sometimes that can result so the prosecution presents a document, for example, that's required evidence from one of those elements. And the defense can show the document's false. It's fabricated. Well, then there's 0 elements on that evidence if the document was the only thing. So there is some room there for the defense. The defense, part of that impeachment would be the opportunity to cross-examine state witnesses, for example. And there's a lot of variance here from state to state. It's not as consistent a framework, set of rules for the grand jury level as it is for the trial level. So I'm speaking very generally here. But there is room. There's something for a defense counsel to do even at the grand jury level. But in any case, you want your defense lawyer on board well before then, because you want your lawyer to be trying to convince the prosecution not to bring this to a grand jury in the first place. If the grand jury never hears the case, there is no indictment. If there's no indictment, you're not going to trial. So yeah, you want your defense attorney on board, which means, is there a cost associated with the grand jury inquiry, is what Joseph is asking. Yes, in the sense that you want your lawyer on board already. And that means you're paying him. And what you're paying him, what would the cost be? Well, I mean, say it's an aggravated assault case with a weapon. So you made someone aware that you have a weapon. I have a gun, for purposes of changing their behavior. Stop, stay back, I have a gun. Well, that could be justified self-defense. It also meets all the conditions for the crime of aggravated assault with a deadly weapon, good for 10 to 20 years in prison, that now you'll have to justify as self-defense. A typical retainer for an ag assault with a deadly weapon charge could be anywhere from $20,000 to $35,000. And that's not to cover the trial, folks. That's for the pretrial portion. So yeah, and that would cover the grand jury portion as well, I would expect. Normally that would be the case. So that's the kind of cost you're talking about. The price of a good car. Not a great car, but a good car. Good new car. And you don't want to skip it. I mean, if you have the means, you don't want to skip it, because hopefully that 20 to 35 grand is going to keep you from getting indicted in the first place. That's what you're really hoping. Okay. One more question, and then I think we'll wrap up on YouTube. And just, if you're a law self-defense member, just stay on board. We'll continue on the law self-defense dashboard without interruption. All right. Let's see. Jack from Texas writes, I enjoyed your blog on BJJ. That's Brazilian Jiu-Jitsu. For those who don't know, I'm about a month in to Brazilian Jiu-Jitsu. I'm the whitest of white belts. Learning quite a bit. And I had done a blog post that was really a commentary on a YouTube video by two BJJ experts, two brothers who run the Gracie University School of Brazilian Jiu-Jitsu Instruction. I'm a student in that school at Gracie University. And they were having a conversation between themselves on YouTube about something they call the Boyd belts. And of course, like any martial art, BJJ has a belt system. There's a white belt, and I don't know all the colors, a purple belt, a blue belt, a brown belt, a black belt, increasing levels of expertise with increasing level of belts. But what they were commenting on is that The belts by themselves don't tell you everything you need to know to distinguish a person's capabilities. They mean a lot, of course, but you also have to consider things like weight. So a lower level belt on someone who's much larger or much younger than, say, a higher level belt, a black belt who's 40 pounds lighter and 20 pounds older, those factors make a difference. Every 10 pounds or 20 pounds may represent a belt level. Every decade in age may represent a belt level. So that someone who's a black belt at 60 may not be competitive against someone with a much more junior belt who's much younger or much larger. And this is useful not just for BJJ purposes, but for self-defense purposes. Because if you're facing a threat, you have to be able, and you're planning on using deadly defensive force, you have to be able to explain why you believed you were reasonably perceiving a deadly force threat. And part of that would involve your age and your weight relative to your attacker. So an older person, 60, 70 years old, who's being attacked by someone who's, 40 pounds heavier than them and 20 pounds lighter, that's not an equal matchup there, is it? So what I liked about that BJJ video was it put into concrete terms the age difference, every decade of age, every 20 pounds of weight, and they translated that into a BJJ belt level. And that makes those variances in age and weight very concrete. I think it's a wonderful way to articulate to a jury how big a difference this makes, because the belt levels in jiu-jitsu, you're completely uncompetitive normally. If your age and weight is the same and you're a lower belt level, a substantively lower belt level, a completely different color, the higher level belt just eats you up alive. So if that same difference happens in the real world in a fight based on weight and age differences, that's important to know in deciding how much force you need to use in self-defense. So I really liked what Hiran and Henner Gracie had to say about that. Those are the two brothers. And so I did my own show commenting on their thoughts on that. Thought it was really great. All right, folks. Well, we're an hour into the YouTube show. I think those are all the Law Self-Defense Platinum member questions I'm going to answer today. I'll wrap up YouTube. Don't forget, you can become a Law Self-Defense member, enjoy the rest of the show. Next on the Law Self-Defense member dashboard, we're going to play the actual video of the rapper-associated shooting in the parking lot that I talked about earlier in the show. We'll do our analysis playing the video. I'm not playing it on YouTube because YouTube is a BITCH. That's it. So you can enjoy either, if you're a member, go over to your lawselfdefense.com member dashboard, become a member at lawselfdefense.com/join. You can do that right now. You'll get in a couple minutes, you'll get your email with your username and password. If you'd like to join us for our upcoming Law of Self-Defense advanced class taking place on Saturday, October 1st. This is the last class of 2022, folks. We only do one or two of these a year. This is the second one. It'll be late spring 2023 before we do this again. This is our full day, live, streamed, taught by me, of course, course on self-defense law. And we only have a few seats left. We want to fill them up, get this all locked up. So we're offering 50% off these last few seats. And you can learn more about that at lawselfdefense.com/advanced. Remember, folks, you don't get to pick the time, place, and manner in which you're attacked. The bad guy does that. It's your duty to make sure you're prepared before the attack, which means I would encourage you not to delay taking this class. It's in a week and a half. Take it now, get the knowledge, document your training so you can introduce this specialized knowledge to your jury if you end up being attacked sometime before next March. All right, folks. I will close that out, and I will say goodbye to YouTube, goodbye to Rumble. If you're watching on the Law Self-Defense member dashboard, don't go anywhere. I'm coming right back to you.